All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Good morning and welcome everyone. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case file KSC BC 2020-07, the Specialist Prosecutor versus Gucati and Haradinaj.
Thank you. Let's take the appearances. Madam Prosecutor.
Good morning, Your Honor. For the SPO are present today Mr. Jack Smith, Specialist Prosecutor, Mr. Matthew Halling, Prosecutor, Ms. Line Pedersen, Case and Evidence Manager, and I'm Valeria Bolici, Prosecutor.
Thank you, Ms. Bolici. Mr. Rees.
I appear on behalf of Mr. Gucati. Your Honour, I'm also assisted by Mr. Bowden, Ms. Stevenson, and Mr. Halliline.
Thank you, Mr. Rees. Mr. Cadman.
Good morning, Your Honours. Appearing for Mr. Gucati&Haradinaj, assisted today by Mr. Solomon, Ms. Frivet, and Mr. Berisha.
And the Registrar.
Thank you, Your Honour. Fidel O'Donnell, Registrar, together with Jonas Nielsen, Judicial Services Division, and the Head of Court Management and Senior Court Officer.
Thank you. Trial Panel 2 is sitting today to pronounce the trial judgment in the case of Specialist Prosecutor versus Gucati and Haradinaj. This judgment is pronounced in public in the name of the people of Kosovo and in the presence of the accused. I will now read a summary of the central findings of the panel. The summary is not a part of the trial judgment, nor is it authoritative. The written judgment is the only authoritative account of the panel's findings. Confidential copies of that judgment will be made available to the parties at the end of this hearing. A public redacted version will be made available to the public following this hearing. This case concerns the acts and conduct of the accused Gucati and Haradinaj between 7 and 25 September 2020. This case is important because it reflects the very reason why the Specialist Chambers was created. This case concerns the proper administration of justice, the integrity of and security of proceedings, and crucially, the safety, well-being, and freedom from fear of hundreds of persons who have come forward to fulfill their civic duty as witnesses. Their protection from intimidation and harm lies at the very foundation of any system of criminal justice, be that domestic or international. Without witnesses, there can be no justice for victims or for society at large. The acts and conduct of the accused challenged that very foundation. I will now turn to the events at issue. The facts of this case can be summarized as follows. On 3 days, 7 September, 16 September, and 22 September 2020, unknown persons delivered 3 sets of documents, referred to as the 3 sets, to the premises of the Kosovo Liberation Army War Veterans Association in Pristina. The documents related to the work and investigations of the Special Investigative Task Force, known as the SITF, and the Specialist Prosecutor's Office, known as the SPO. After each delivery, the accused called and hosted a press conference at which they discussed and made available to journalists the material that had been delivered to them. In addition, the accused also participated in over 20 media interviews, together, alone, or in the presence of others, where they discussed, read from, or described the contents of the 3 sets. They also published articles on social media regarding the three sets and made disparaging and insulting remarks regarding the witnesses and potential witnesses whose names appeared in those documents. A single judge of the specialist chambers and the SPO issued orders in an effort to stop the multiplication and dissemination of documents. Despite these orders, the accused continued to make available to journalists the information contained in the three sets. At trial, the accused did not dispute that they had participated in the three press conferences and in the associated media appearances, nor did they dispute that they had been in the possession of the three sets and made available to the media much of the information contained in those sets. They claimed instead to have acted out of a concern for the interests of the public and to have been entrapped by the SPO to undertake their actions. I will now turn to the charges. As a result, the specialist prosecutor charged the accused with 6 counts of violations of the Kosovo Criminal Code. Counts 1 and 2, obstructing official persons in performing official duties under Article 401 of the Criminal Code. Count 3, intimidation during criminal proceedings under Article 387 of the Criminal Code. Count 4, retaliation under Article 388 of the Criminal Code. And counts 5 and 6, violating the secrecy of proceedings under Article 392 of the Criminal Code. The specialist prosecutor alleged that the accused were criminally responsible for the offenses through commission, alone or in co-perpetration, attempt, agreement to commit, assistance, and incitement. The law applicable to these offenses and modes of liability is set out in detail in the judgment. I will now move to the panel's findings on the three sets and the corresponding batches. The panel is satisfied that the SPO seized from the War Veterans Association on 3 occasions remnants of the three sets, which correspond to what the SPO described as batches 1, 2, and 3. The SPO also received from a media outlet a 4th set taken by a journalist at the first press conference. This corresponds to batch 4. The batches contained a variety of sensitive information, including requests for assistance addressed by the SITF to the competent Serbian authorities, referred to as SITF requests, which contain the names and personal details of hundreds of witnesses. Responses from the Serbian War Crimes Prosecution Office to the SITF requests, referred to as responses, and an internal SPO work product analyzing evidence and related legal considerations in relation to 5 SPO suspects, which also contain the names of 150 witnesses and potential witnesses. The panel is satisfied that the material in question was authentic and belonged to the records of the SITF or SPO investigations. The panel is further satisfied that the material was treated as confidential by the SITF and the SPO. I will now turn to the panel's findings on the counts. The panel will first address whether the accused are guilty of violating the secrecy of proceedings under counts 5 and 6, then the allegations of intimidation and retaliation under counts 3 and 4, and lastly the allegations of obstructing official persons in performing official duties under counts 1 and 2. I therefore now turn to count 5, which concerns the offense set out in Article 392, Paragraph 1 of the Kosovo Criminal Code. That is the offense of revealing, without authorization, information disclosed in any official proceeding which must not be revealed according to law or has been declared to be secret by a decision of the court or a competent authority. The panel is satisfied that the SITF and SPO is an authority competent to declare its records secret within the meaning of Article 392, Paragraph 1. The panel is also satisfied that the SITF requests and the responses contained in batches 1, 2, and 4, and the documents in batch 3 qualify as information that has been declared secret by a competent authority. The same material also qualifies by virtue of Article 62 of the law as information which must not be revealed according to the law. I will refer to these documents as protected information. The panel is satisfied that the accused revealed the protected information within the meaning of Article 392, Paragraph 1 of the Kosovo Criminal Code by the following actions: displaying the documents and allowing those present at the 3 press conferences to inspect them, showing the documents to reporters, inviting or allowing those with cameras to film or photograph the documents, inviting or allowing those present to take documents with them, and introducing, describing, or referring to the content of the documents during the 3 press conferences and other media appearances. The panel also finds that, for the purposes of this offense, journalists are members of the public. The panel is satisfied that the accused acted with direct intent in revealing the protected information. This is apparent in particular from their actions, their vows to continue to publish any documents received, stating that it was their duty to do so, their repeated encouragement of journalists to publish documents, and their indications that more deliveries of such documents were welcome. The panel therefore finds that the SBO has established beyond a reasonable doubt the offense under Count 5 in relation to both accused. Count 6 concerns both a basic and an aggravated offense. The basic form is the offense of revealing information on the identity or personal data of a person under protection in the criminal proceedings or in a special program of protection under Article 392, Paragraph 2 of the Kosovo Criminal Code. The aggravated form under Article 392, Paragraph 3 applies when serious consequences result from revealing the identity of protected persons or when criminal proceedings are made impossible or severely hindered. The panel is satisfied that the witnesses and potential witnesses whose names and personal data were contained in the protected information qualify as persons under protection in criminal proceedings within the meaning of Article 392, Paragraph 2 of the Kosovo Criminal Code. The panel notes that the SITF and SPO did not publicly disclose the names of these witnesses and potential witnesses in the framework of its investigations. The panel finds that the accused revealed the identities and/or personal data of witnesses and potential witnesses under SITF or SPO protection in the same manner as they revealed protected information. In addition, the accused pointed at the presence in the 3 sets of names, past and present residents, phone numbers, ethnicities, interview locations, and contents of statements of witnesses. They also invited the journalists to acquaint themselves with this information. Additionally, Mr. Haradinaj named at least 5 witnesses or potential witnesses. The panel is further satisfied that the accused acted with direct intent in revealing the names and personal data of witnesses and potential witnesses. The conduct of the accused resulted in serious consequences within the meaning of Article 392, Paragraph 3 for 2 witnesses who were relocated, witnesses who were subject to emergency risk planning, and for at least 1 person who was publicly named as a witness. Both accused were aware that such consequences could occur as a result of their actions, and they acceded to that occurrence. The panel is, however, not satisfied that the accused's conduct made impossible or severely hindered SPO investigations. The panel therefore finds that the SPO has established beyond a reasonable doubt the basic form of the offense under Count 6 and the aggravated form only as regards serious consequences in relation to both accused. I will now move to Counts 3 and 4. Count 3 concerns the offense of intimidation. Under Article 387 of the Kosovo Criminal Code, whoever uses force or serious threat or any other means of compulsion, a promise of a gift, or any other form of benefit to induce another person to refrain from making a statement, or to make a false statement, or to otherwise fail to state true information to the police, a prosecutor, or a judge when such information relates to obstruction of criminal proceedings, is guilty of that offense. The panel found that the accused revealed the identity and/or personal data of hundreds of witnesses and potential witnesses contained in the protected information. In their public appearances, the accused also drew attention to the large number of witnesses they identified in the documents, and they publicly and repeatedly pointed at the presence of such names therein. Approximately 70 to 80% of the 3 sets were disseminated in an indiscriminate manner and without meaningful precaution. The aim was to reach a large public, and the accused left to chance where and in whose hands the revealed information would end up. Moreover, the accused expressly stated that the public, including any witnesses, now knew that others knew who they were. The accused made repeated statements to the effect that this court was unable to guarantee the privacy and security of its witnesses, thereby further emphasizing their vulnerability. And the accused used the collective platform of the War Veterans Association and their official functions within that organization to carry out their deeds. Furthermore, the accused publicly questioned the veracity of the information provided by witnesses, calling them, I quote, liars, and claiming without any credible basis that they provided evidence to get benefits or because they were coerced. The accused also referred to witnesses and potential witnesses using derogatory and threatening language, calling them, I quote, traitors, spies, collaborators, and Albanian speakers, echoing a well-known rhetoric which was intended to arouse hostility toward those who chose to cooperate with the SPO. The message of the accused to those witnesses was, now that everyone knows who you are, no one can protect you, because you are a traitor, a spy, a collaborator, an Albanian speaker who does not have, and I quote, the best interests of Kosovo and the KLA at heart. These acts and statements took place in a climate of witness intimidation. The panel is aware that insidious forms of witness intimidation have repeatedly deprived victims of the truth concerning crimes committed against them and have seriously impeded efforts at reconciliation in post-conflict societies. The authorities in Kosovo and at the ICTY have for years struggled to deal with a climate of witness intimidation that has severely affected investigations and prosecutions of crimes that took place in Kosovo. The accused knew this full well. The panel finds that a serious threat stemmed from the accused's acts and statements, which would have created serious fears and concerns for many witnesses or potential witnesses. The panel is further satisfied that the accused used this serious threat with the direct intent to make witnesses and potential witnesses fearful and therefore hesitant to provide information in investigation concerning ex-KLA members. The accused's conduct was a means to an end to prevent the SPO from effective investigations and prosecutions of ex-KLA members. Simply put, without witnesses there would be no trials, and without trials there would be no convictions of those who were described by one of the accused as Kosovo's sons. The panel finds that the SPO has established beyond reasonable doubt the offense of Count 3 in relation to both accused. Count 4 pertains to the offense of retaliation. Whoever takes any action harmful to any person, including interference with lawful employment or livelihood of any person, with the intent to retaliate for providing truthful information relating to the commission or possible commission of any criminal offense to police, an authorized investigator, a prosecutor, or a judge, is guilty of an offense under Article 388, Paragraph 1 of the Kosovo Criminal Code. The panel has found under Count 3 that the acts and statements of the accused amounted to a serious threat. The same finding is relevant for the purpose of Count 4. The acts and statements of the accused amounted to action harmful to any person within the meaning of Article 388, Paragraph 1 of the Code. The panel emphasizes that the claims of the accused that the accounts of the witnesses were untruthful do not establish in themselves that the accused held this belief. The panel, however, notes that the SPO adduced no evidence to contradict such statements. This in no way raises questions about the credibility of witnesses or potential witnesses whose names appeared in the protected information. Nonetheless, under Article 388, Paragraph 1, it is the SPO's burden to show that the accused were aware that the information of the witnesses was, at least to a certain extent, truthful. The SPO failed to establish that the accused had such an awareness. For these reasons, the panel finds that the SPO has failed to establish that the accused acted with the requisite intent in respect of any witness whose identity and or personal data was revealed by them. The panel therefore finds that the SPO has failed to establish beyond a reasonable doubt the offense under Count 4 in relation to either accused. I will now move to Counts 1 and 2. Count 1 concerns the offense of obstructing official persons by force or serious threat. Whoever by force or serious threat obstructs or attempts to obstruct an official person in performing official duties or, using the same means, compels him or her to perform official duties is guilty of an offense under Article 401, Paragraph 1 of the Kosovo Criminal Code. This is the basic form of this offense. An aggravated form applies where the offense is committed against particular categories of persons, including a judge, a prosecutor, or an official of a court. The panel found under Count 3 that the acts and statements of the accused amounted to a serious threat. The same finding is relevant for the purpose of Count 1. For these reasons, the panel finds that the acts and statements of the accused amounted to a serious threat, while a serious threat within the meaning of Article 401, Paragraph 1 of the Code. The panel reiterates that the performance of official duties within the specialist chambers and the SPO are critically dependent on the willingness and ability of witnesses to come forward and give their evidence freely. The panel has established that the accused conduct resulted in serious consequences for a number of witnesses or potential witnesses, but received no evidence that any of these persons or any other witnesses were in fact induced by the conduct of the accused to no longer give evidence to the specialist chambers or to the SPO. The SPO has also not demonstrated any concrete and actual impediment to its investigations that could be imputed to the conduct of the accused. There is also no indication that as a result of the division of time and resources, the SPO was prevented from or delayed in carrying out its regular functions. For these reasons, the panel finds that the SPO has failed to establish that the acts and statements of the accused obstructed officials of the specialist chambers or the SPO in performing their duties. The panel nonetheless recalls that the offense under Article 401, Paragraph 1 of the Code can also be committed if obstruction is attempted but not completed. Having found that the acts and statements of the accused amounted to a serious threat, the panel finds that the accused attempted to obstruct officials of the specialist chamber and SPO in performing their duties. The panel is satisfied that the accused did so with direct intent. This is apparent from the claims by the accused that it was their duty to reveal the protected information in order to expose how, in their words, scandalous, shameful, and unacceptable the Specialist Chambers and the SPO was for, I quote, collaborating with Serbian authorities and unreliable witnesses and for not protecting such witnesses. In performing what the accused described as their duty to reveal the protected information, the accused also professed that the collapse of the Specialist Chambers was inevitable. Both accused made clear their intentions to disobey orders of the Specialist Chambers and of the SPO. Moreover, both accused expressly declared that they wanted to stop or damage the proceedings of the Specialist Chambers so that what they described as a worthless and biased court does not prosecute, I quote, Kosovo's sons. The panel finds that the accused's acts and statements clearly reflect a desire to obstruct the collection of witnesses' evidence by SPO investigators and prosecutors, which qualifies as an aggravated form of the offense. The panel therefore finds that the SPO has established beyond a reasonable doubt the basic and aggravated form of the offenses under count 1 in relation to both accused. Count 2 concerns the offense of obstructing official persons by common action of a group. Whoever participates in a group of persons which by common action obstructs or attempts to obstruct an official person in performing official duties or using the same means compels him or her to perform official duties is guilty of an offense under Article 401, Paragraph 2 of the Kosovo Criminal Code. Count 2 also encompasses the same aggravated form as under Count 1 and another aggravated form which applies when a leader or organizer of the group commits the offense. The panel is satisfied that the accused did not act alone in revealing protected information. The evidence establishes that Mr. Gucati, Mr. Haradinaj, and Mr. Fatan Klinaku acted as a group, dividing among themselves the tasks of organizing the 3 press conferences, presenting the information contained in the 3 sets, liaising with the SPO, and expressing common views during the media appearances about the revelation of protected information and the obstruction of the Specialist Chambers and the SPO. As established under Count 1, the accused acted with direct intent to obstruct officials of the Specialist Chambers and SPO in performing their functions. The panel considers that this finding also applies to Count 2 and finds that the accused acted in a group with direct intent to obstruct, by common action, officials of the Specialist Chamber and SPO in performing their functions. The panel is satisfied that Mr. Gucati's authority as chairman of the KLA-WVA was relied upon as part of the efforts by the accused and Mr. Klinaku to reveal protected information and obstruct officials of the Specialist Chambers and SPO. For these reasons, the panel is satisfied that Mr. Gucati acted as the leader of the group. Mr. Haradinaj acted under the authority of Mr. Gucati and had a significant role as a member of the group. The panel is not satisfied that he acted as its leader or organizer. The panel therefore finds that the SPO has established beyond reasonable doubt the offense in Article 401, Paragraph 2 and 5 in relation to both accused. The panel also finds that the SPO has established beyond a reasonable doubt the aggravated form of the offense in Article 401, Paragraph 3 in relation to Mr. Gucati. The next issue is modes of liability. Turning to the question of the nature of the accused's participation in these offenses, the panel finds that the accused jointly participated and substantially contributed as co-perpetrators to the commission of the offenses under Counts 1, 3, 5, and 6. The panel also finds that Mr. Gucati and Mr. Haradinaj individually perpetrated the offense under Count 2. In light of the above, the panel finds that the accused are criminally responsible as co-perpetrators for the offenses under counts 1, 3, 5, and 6, and as individual perpetrators for the offense under count 2. I turn now to defenses, which are arguments raised by the accused to justify their actions. As regard public interest, the panel finds that there is no credible basis to conclude that the protected information revealed by the accused contained indications of improprieties attributed to the SITF, SPO, or that the accused's actions were justified by the pursuit of a claimed public interest. The panel further finds that neither accused can be regarded as a whistleblower, and that their conduct falls outside the protection guaranteed to such persons under the European Convention on Human Rights and the law of Kosovo, including the Constitution. Turning to the claim of entrapment, the panel finds that the defense was afforded a full and fair opportunity to put forward this claim based on the standards laid down by the European Court of Human Rights, to which the panel closely adhered. The panel further finds that neither the accused's contemporaneous statements nor their evidence at trial indicates an objective basis to believe that the accused had been entrapped. The panel has carefully assessed the propositions put forward by the Gucati defense as circumstantial evidence of entrapment and finds that they do not provide a reasonable basis for an inference of entrapment. The panel finds that the entrapment claim is wholly improbable and unfounded. As regards mistake of law, the panel is satisfied that during the indictment period the accused knew that their conduct was prohibited and that in any event there were no justifiable reasons not to know that it was prohibited. The panel therefore finds that the accused's criminal responsibility cannot be excluded by considerations of public interest, a claim of entrapment, or a defense of mistake of law. The panel also finds that the accused's criminal responsibility cannot be excluded by the defenses of extreme necessity, mistake of fact, and acts of minor significance. I turn now to sentencing. The accused are responsible for grave offenses which imperil the proper administration of justice. Despite the issuance of orders by the single judge and the SPO, the accused continued to disseminate on a wide scale protected information, including the names of hundreds of protected witnesses, using organized press conferences and other media appearances. They did so repeatedly and enthusiastically, and they vowed to do so again. The accused treated those who chose to cooperate with the court in its search for the truth with contempt and insults, and spoke in terms that could only have been intended to persuade them not to provide any further information to the SPO, nor to testify in any future trial. The conduct of the accused affected a large number of people and caused fear and concern among some of them. The accused showed no concern for the consequences or possible consequences of their actions. They acted brazenly, openly, and indiscriminately, and without regard for the rule of law or the authority of this court. This judgment clearly paints these acts for what they are, criminal and not patriotic, a threat to justice and not the pursuit of any public interest. The panel finds that there are no further aggravating factors as regards the accused's contribution to these grave offenses. The panel considers as mitigating factors both accused's family and or health situation, and for Mr. Gucati, his community work. This completes the summary of the panel's findings. I shall now read out the disposition. Mr. Hisni Gucati, please stand. In the name of the people of Kosovo, and for the reasons set out in the judgment and summarized above, and having considered all of the evidence and the arguments of the parties, the panel, pursuant to Articles 43 and 44 of the law and Rules 158, 159, 163, and 165, finds you, Mr. Gucati, guilty of A, count 1, obstructing official persons in performing official duties by serious threat under Articles 15, paragraph 2, and 16, paragraph 3 of the law, and Articles 17, 31, and 401, paragraphs 1 and 5 of the Kosovo Criminal Code. B, count 2, obstructing official persons in performing official duties by participating in the common action of a group under Articles 15, paragraph 2, and 16, paragraph 3 of the law, and Articles 17 and 401, paragraphs 2, 3, and 5 of the Kosovo Criminal Code. C, count 3, intimidation during criminal proceedings under Articles 15, paragraph 2, and 16, paragraph 3 of the law, and Articles 17, 31, and 387 of the Kosovo Criminal Code. D, count 5, violating secrecy of proceedings through unauthorized revelation of secret information disclosed in official proceedings under Articles 15, paragraph 2 and 16, paragraph 3 of the law, and Articles 17, 31, and 392, paragraph 1 of the Kosovo Criminal Code. And E, count 6, violating secrecy of proceedings through unauthorized revelation of the identities and personal data of protected witnesses under Articles 15, paragraph 2 and 16, paragraph 3 of the law, and Articles 17, 31, 392, paragraphs 2 and 3 of the Kosovo Criminal Code. The panel finds you not guilty of count 4, retaliation. You are hereby sentenced by this panel to a single sentence of 4.5 years of imprisonment with credit for time served and to a fine of €100 to be paid by 18 July 2022. Mr. Gucati, you may be seated. Mr. Nasim Haradinaj, please stand. In the name of the people of Kosovo, for the reasons set out in the judgment and summarized above, and having considered all of the evidence and the arguments of the parties, the panel, pursuant to Articles 43 and 44 of the law and Rules 158, 159, 163, and 165 of the rules, finds you, Mr. Haradinaj, guilty of A, count 1, obstructing official persons in performing official duties by serious threat under Articles 15, paragraph 2, and 16, paragraph 3 of the law, and Articles 17, 31, and 401, paragraphs 1 and 5 of the Kosovo Criminal Code. B, count 2, obstructing official persons in performing official duties by participating in the common action of a group under Articles 15, paragraph 2 and 16, paragraph 3 of the law, and Articles 17 and 401, paragraphs 2 and 5 of the Kosovo Criminal Code. C, count 3, intimidation during criminal proceedings under Articles 15, paragraph 2 and 16, paragraph 3 of the law, and Articles 17, 31, and 387 of the Kosovo Criminal Code. D, count 5, violating secrecy of proceedings through unauthorized revelation of secret information disclosed in official proceedings under Articles 15, paragraph 2, and 16, paragraph 3 of the law, and Articles 17, 31, and 392, paragraph 1 of the Kosovo Criminal Code. And E, count 6, violating secrecy of proceedings through unauthorized revelation of the identities and personal data of protected witnesses under Articles 15, paragraph 2, and 16, paragraph 3 of the law, and Articles 17, 31, 392, paragraphs 2 and 3 of the Kosovo Criminal Code. The panel finds you not guilty of count 4, retaliation. You are hereby sentenced by this panel to a single sentence of 4.5 years of imprisonment with credit for time served and to a fine of €100 to be paid by 18 July 2022. Mr. Haradinaj, you may be seated. The registry shall now distribute to the parties the trial judgment in electronic form, both confidential and public redacted versions. Madam Court Officer, please distribute the filings.
Your Honors, the confidential trial judgment and the public redacted version has now been notified electronically to the relevant and authorized recipients.
Thank you, Madam Court Officer. Please now provide certified copies of the confidential English version to the accused. This is filing 611.
Your Honour, while that's being done, can I ask for clarification of one matter? Is the term announced to 4.5 years before or after deduction of time served?
4.5 years, and then they get credit for time
To be
served.
deducted from the 4.5 years?
Yes.
I'm grateful, thank you.
The Albanian version shall be served on the accused once it is ready. The court stands adjourned.
Your Honour, one question before you rise. I do apologise. Do we have a timeline on the Albanian version? It's going to be very difficult for us
No,
to
we
take
don't.
instructions.
It has to be translated.
All rise.